Hey everyone, and welcome back to the channel. Today we're diving headfirst into the fascinating, sometimes confusing world of corporate law with a breakdown of the Indian Companies Act of 2013. Now I know what you're thinking. Corporate law, that sounds about as exciting as watching paint dry. But trust me on this one, folks. Understanding even the basics of this act can be incredibly useful, whether you're an entrepreneur looking to launch your own startup, an investor trying to navigate the market, or just someone who wants to understand how businesses work on a deeper level. We're going to be taking a deep dive into sections 3 through 22, which lay the very foundation of a company's existence. From incorporation and registration to understanding the roles of the Memorandum and Articles of Association. These sections are the essential building blocks of any company operating under the Act. So buckle up, grab your notebooks and maybe a cup of coffee, because we're about to embark on a journey to demystify the legal jargon and uncover the core principles governing companies in India. Let's dive in. So, you want to start a company, huh? Well, Section 3 is the first stop on your entrepreneurial journey. This section lays out the ground rules for how many people you need to get your company off the ground. If you're thinking of a private company, you need at least 2 founding members. For a public company listed on the stock exchange, you'll need a minimum of 7 people. But hold on, there's a special category for all you lone wolves out there, the one-person company, or OPC. As the name suggests, you can fly solo and be the sole director and shareholder. No matter what type of company you choose, everyone involved needs to be on the same page. That means agreeing to the company's grand plan, outlined in a document called the Memorandum of Association, or MOA. We'll talk more about that in a bit. And of course, no company can just magically appear in the government's database. You have to go through a formal registration process. Don't worry, we'll break down that process in a later section. So remember, Section 3 is the starting line of your company's marathon, and it all begins with the right number of people and a shared vision. All right, we've assembled our founding team. Now it's time to give our company a soul, a purpose, an identity. That's where Section 4 comes in with the all-important Memorandum of Association, or MOA. Think of this document as your company's constitution, its DNA, the blueprint that defines its very existence. It's not just a formality, folks. The MOA is a legally binding document, and it must clearly state some crucial details. First up, the name of your company. This is how the world will know you, so choose wisely. You'll also need to provide the registered office address. That's the company's official headquarters. And perhaps the most important part, the MOA lays out the company's objectives. This objects clause outlines what your company intends to achieve, its reason for being. It's like a mission statement on legal steroids. Finally, the MOA will also define things like the liability of its members, how the capital is structured, and who the initial subscribers are. So, we've got the company's grand plan laid out in the MOA. Now it's time to figure out the nuts and bolts of how we're going to make it all happen. That's where Section 5 swoops in with the Articles of Association, or AOA. If the MOA is the Constitution, think of the AOA as the Rulebook, the detailed set of bylaws that govern the company's internal affairs. The AOA covers a wide range of operational details, ensuring things run smoothly. We're talking about how meetings will be conducted, from board meetings to shareholder meetings, the rules of engagement, if you will. Then there's the nitty-gritty of how directors are appointed, how they function, their powers and responsibilities. And of course, the AOA outlines the process for transferring shares, which is particularly important for shareholders looking to buy or sell their stake in the company. Basically, the AOA provides a roadmap for how the company will be managed and administered on a day-to-day basis. Now picture this. You're cruising along, following your MOA and AOA, everything's hunky-dory. Suddenly you hit a roadblock, a conflict between what your company documents say and what the Companies Act stipulates. Who wins? Well, Section 6 swoops in with a resounding answer. The Companies Act reigns supreme. This section establishes a clear hierarchy. The Companies Act of 2013 trumps any conflicting provisions found within a company's MOA or AOA. Think of it like this: the Act is the overarching law of the land, and company documents must operate within its boundaries. It's like that old saying, you can't fight City Hall, or in this case, you can't fight the Companies Act. This ensures that all companies, regardless of their internal rules, are held accountable to the same legal standards set forth by the Act. Okay, we've got our MOA and AOA prepped and ready. Now, it's time to make things official, to bring our company into the realm of legal existence. That's where Section 7 steps in, outlining the registration process. Think of this as getting your company's birth certificate. First things first, you'll need to gather your paperwork. That includes the MOA and AOA, of course, along with ID and address proof of all the subscribers, the founding members who are putting their skin in the game. But it's not just about paperwork. You'll also need a declaration from professionals like chartered accountants or company secretaries, confirming that everything is in order. Once you've got all your ducks in a row, you submit it all to the Registrar of Companies, or ROC. If everything checks out, the ROC issues a certificate of incorporation. Boom! Your company is officially official, a legal entity recognized by the government. Now, not all companies are created equal, at least not in terms of their primary objectives. Section 8 shines a light on a special category, companies formed for charitable purposes. These organizations are all about giving back, promoting art, education, social welfare, you name it. Unlike traditional for-profit businesses, these companies operate on a not-for-profit basis, meaning their primary goal isn't to line their pockets but to serve a greater good. But just because they're not driven by profit doesn't mean they can operate without oversight. Section 8 requires these charitable companies to obtain a license from the central government. This ensures that their activities align with their stated charitable objectives and that they're operating transparently and ethically. Hold on to your hats, folks, because things are about to get conceptual. Section 9 delves into a fascinating legal concept. The company is a separate legal entity. That means once your company is registered, it's no longer just a group of people working together, but a distinct legal person in the eyes of the law. This separate legal entity status comes with some pretty significant implications. For starters, the company can own property in its own name, separate from its members. It can also enter into contracts, sue, or be sued, just like an individual. But here's the kicker: even if the members change, if the shareholders come and go, the company itself continues to exist. It's like this immortal entity that persists regardless of the changes in its human membership. We've talked about the MOA and AOA as the company's guiding documents, but Section 10 takes it a step further, highlighting their legal weight as binding contracts. That's right, these documents aren't just suggestions, they create legal obligations. First and foremost, the MOA and AOA act as a contract between the company itself and its members. This means both parties have a legal duty to uphold the provisions outlined in these documents. But it goes beyond that. Section 10 also establishes the MOA and AOA as a contract among the members themselves. This means shareholders are bound by the agreements outlined in these documents, ensuring everyone is on the same page and preventing internal disputes. All right, time for a reality check. You can have the most brilliant business plan, a rock-solid MOA, and a comprehensive AOA, but none of it matters if you don't have the capital to back it up. That's where Section 10A steps in, adding a layer of financial accountability. This section, a relatively recent addition to the Act, mandates that a company must file a declaration within 180 days of incorporation. This declaration confirms that the company has received the share capital promised by its initial subscribers. It's like saying, we're not all talk, folks, we've got the financial backing to make this happen. This provision prevents companies from starting operations without the necessary capital and ensures transparency in the early stages of a company's life. We've talked about the company as a separate legal entity, but even legal entities need a place to call home, right? That's where Sections 11 and 12 come in, emphasizing the importance of a registered office. Every company, under the Companies Act, is required to have a registered office. It's not just a formality, it's the company's official address, the place where all legal correspondence will be sent. Think of it as the company's mailbox for all things official. But here's the catch: you can't just choose any random address and call it a day. The registered office must be established within 30 days of the company's incorporation. This ensures that the government and other stakeholders know where to reach the company for legal and administrative purposes. The business world is constantly evolving, and sometimes a company needs to adapt its founding documents to keep pace with the changing times. Sections 13 through 15 provide a roadmap for altering the company's DNA, the MOA, and the Rulebook, the AOA. Let's say your company wants to expand into a new line of business, or maybe you decide to change the company's name to reflect a new brand identity. These changes, while significant, are possible under the Act, but they require a formal process. Any alteration to the MOA or AOA requires the company to pass a special resolution, a decision made by shareholders with a higher majority vote than usual. Think of it as a supermajority vote, highlighting the importance of these changes. Once the resolution is passed, the company must inform the Registrar of Companies about the alterations. Imagine this: you've poured your heart and soul into building a brand, establishing your company's identity in the market. Then, out of nowhere, another company pops up with a name confusingly similar to yours, creating confusion among customers and potentially harming your business. That's where Section 16 comes in to prevent a corporate identity crisis. This section empowers the Registrar of Companies or the government to step in and ask a company to change its name if it's deemed too similar to an existing company. This is to prevent unfair competition and protect the hard-earned brand identity of companies. It's like a trademark protection mechanism within the Companies Act, ensuring that companies have a distinct identity in the marketplace and that consumers aren't misled by confusingly similar names. Transparency is crucial in the corporate world, and Section 17 promotes this by ensuring that members have access to the company's governing documents. After all, these documents outline the company's objectives, rules, and how it operates. This section mandates that every company must provide a copy of its MOA and AOA to any member who requests it. This means shareholders have the right to access these documents and stay informed about the company's framework. Of course, companies can charge a reasonable fee for providing these copies, but the key takeaway is that these essential documents shouldn't be shrouded in secrecy. Transparency and access to information are vital for building trust and accountability within a company. Sometimes a company's needs evolve, and its legal structure needs to evolve along with it. Section 18 provides a mechanism for companies to shift gears, allowing a private company to convert into a public company or vice versa. This conversion process isn't a walk in the park, though. It involves a series of steps outlined in the Act, including passing special resolutions, obtaining necessary approvals, and filing the required documents with the Registrar of Companies. Think of it as a legal metamorphosis, transforming the company's structure and, in turn, its relationship with shareholders and the public. This flexibility allows companies to adapt to changing market conditions, growth opportunities, or funding requirements. Now, this might seem a bit self-explanatory, but Section 19 lays down the law specifically prohibiting a company from holding shares in itself. That's right, no corporate narcissism allowed. A company can't be its own shareholder. It's a conflict of interest and can lead to all sorts of complications in terms of ownership, control, and voting rights. Similarly, a company is also barred from owning shares in its holding company. This prevents circular ownership structures where a company essentially owns itself indirectly, creating a tangled web of corporate control. In the digital age, communication is key, even more so in the formal world of corporate law. Section 20 outlines the various ways official documents can be legally served or delivered, ensuring that communication channels are clear and legally sound. Traditional methods like sending documents by registered post or delivering them by hand are still valid options. But recognizing the rise of technology, the Act also recognizes email as a legitimate mode of service. However, it's not as simple as firing off an email and calling it a day. The Act outlines specific requirements for email service, such as ensuring the email address is correct and that there's proof of delivery. This ensures that documents are deemed legally served and there's no room for "I didn't get the email" excuses. In the world of legal documents, signatures carry immense weight. Section 21 emphasizes the importance of proper authorization for signing documents on behalf of a company, ensuring accountability and preventing fraudulent activities. Any document that requires the company's signature, whether it's a contract, an agreement, or an official filing, must be duly authorized by a designated individual. This could be a director of the company, a key managerial personnel, or someone specifically authorized in writing by the board or other authorized personnel. This requirement prevents unauthorized individuals from signing documents and binding the company to agreements without proper consent. It's all about maintaining a clear chain of authority and ensuring that signatures represent a legitimate commitment from the company. Imagine a company having to sign hundreds of contracts, agreements, and other legal documents. It would be practically impossible for directors or key managerial personnel to personally sign each one. That's where Section 22 steps in, providing a practical solution through authorized representatives. This section allows companies to appoint individuals as authorized representatives, granting them the power to sign documents on the company's behalf. Think of it as a power of attorney for specific tasks or transactions. This delegation of authority is particularly useful for routine or high-volume transactions, streamlining operations and ensuring efficiency. Of course, the authorization must be clearly defined in writing, outlining the scope of the representative's authority and the types of documents they are allowed to sign. And there you have it, folks. We've navigated the twists and turns of the Companies Act of 2013, covering key sections from 3 to 22. We've journeyed from the birth of a company to its complex inner workings, exploring the intricate web of legal requirements and obligations, from the importance of a company's constitution, the MOA, to the nuts and bolts of its operational rulebook, the AOA. We've demystified the jargon and uncovered the principles that govern companies in India. We've also delved into the significance of registration, the concept of a separate legal entity, and the crucial role of transparency and accountability. We hope this breakdown has shed light on the essential aspects of the Companies Act, empowering you with the knowledge to navigate the corporate landscape. Don't forget to like, share, and subscribe for more informative content, and stay tuned as we delve deeper into the fascinating world of business law.